Good morning, everybody, and happy Sunday. Thank you for joining us for another episode of North Alabama Law Review presented by Johnston and Weston. I'm your host, Shauna Hill, and this morning we have joining us Mr. Bennett Triggers and Mr. Mickey Gentle. Good morning, guys.
Good morning.
Good morning. Joining us this morning. So today we're going to open up with a topic that I'm pretty sure most of us can resonate with at one point, whether it be us personally or a family member. And this is going to be divorce. Divorce can have a big toll on you. It can be a lengthy process or a short process, depending on if it's a contested divorce or an uncontested divorce. So today we're going to talk about the differences between the two and how to navigate each one. Mickey, Bennett, which one of you guys want to start first on this topic?
I can start with that. Divorce is something a lot of people will face in their lifetime, and it's a matter of whether that divorce is going to be uncontested or contested. Now, typically speaking, the uncontested divorce is when the parties have agreed on every issue, or at least most of the issues, and they'll come and see us. If they don't have quite everything hammered out, they'll come and see us, and we can advise them about how they might turn on this particular issue or that issue. And so once the agreement is set in, we can type that up and get it signed. The contested matters is pretty much as it sounds, in that they don't have much agreement or any agreement whatsoever, and a divorce complaint would need to be filed, and ultimately, if it doesn't settle before, then a judge would have to make that decision. That's pretty much the nutshell, the nuts and bolts of contested as opposed to uncontested divorces.
What about timing, Mickey? What's the time wait? When you file an uncontested divorce, is there any time limits on that as far as how long you have to wait to get that divorce finalized?
Once the paperwork is typed and everybody comes to sign, then the divorce gets filed. And that is normally a 30-day waiting period that the judge will hold the paperwork there and then sign the divorce after the 30 days has expired. And typically, as my understanding is, that that's an opportunity that if there's any kind of a cooling off period there, that the couple decides they wish to reconcile, that would allow them simply to file a motion to dismiss, and that divorce never goes through if that happens. Many times it does not happen. I've had just a small few of those that actually happen that way. But normally that 30-day waiting period comes, and the judge will sign right around that 30-day mark.
Now, it sounds easy enough if you have an uncontested divorce, all parties agree on everything. So I think a big question is, well, if we agree on anything, why would I need an attorney to represent me? And I'm pretty sure you guys can cover that pretty well.
I will start with that one. I like that part. That's actually what I was about to talk about. Is anything truly ever uncontested when you're talking about two people that can't get along? One thing you got to keep in mind is you need to go see an attorney. You need to protect your rights, because once that order comes out, those things that you agreed to are final, unless you can go back to the courts later on and spend more money and time and effort to get those agreements changed, and that's harder to do than you think. So the point is it's good to have a third party who's not going through the emotions of a divorce. Whether you can get along or not doesn't mean there's still not feelings for these individuals, and when those emotions come into play, it's easy for somebody to take advantage of you in that state. And so be wary of rushing to sign an agreement because you just want this person out of your life as quick as possible. You may be doing a lot of damage to your own personal finances and your stability in the future by doing that. So it's best to go speak to an attorney. Even if you think you've got everything worked out, at least have them help with the documents and advise you on what you're getting yourself into by making certain agreements. Especially in uncontested divorces sometimes involve children, not often, but they do sometimes, and parents can agree, and they'll sign, and then they'll turn around and 6 months later say, why did I agree to this limited visitation with my kids, or why did I agree to this exorbitant amount of child support, or, just all kinds of questions come in later on, which turn into regret, because then you've got to go back through the court system to get those things changed. So be very wary of doing it yourself, because there's just lots of pitfalls that you may not realize unless you've been practicing in the area of divorce law for a long time. You might run into some of those pitfalls trying to save a little money and do it yourself, ended up costing yourself quite a bit of money in the long run. Mickey, you want to address any issues with that?
Yeah, I pretty much echo that myself, because if one spouse draws up a proposed uncontested matter and sends it to the other spouse, it's good to let an attorney look at that and to see just exactly what it says. I've often told my clients when they've called and asked the question, do I need to have this reviewed? And my response has always been that I think you do need to have it reviewed just to make sure that you're in agreement with what's being proposed. I've offered many times to tell a client to bring it on into the office. I will look at it. I'll tell you what it says. And if you are in agreement with it, you can sign it. We can notarize it at my office. And if you're not in agreement with it, you can tell me what you disagree with so I can speak to the other person or their attorney, as the case may be, and hammer out where you do disagree and see if that can be resolved in some way or another. So I would have to echo that trying to do it yourself often winds up being a disaster for the person doing that, and often costs one or the other or both parties a whole lot more money than it otherwise would have.
And a whole lot more heartache.
Yes.
Let's dive into contested divorces now. Now, contested divorces, I'm pretty sure you guys probably see those more than uncontested. Usually, if you're at the point of divorce, you're probably not agreeing on much of anything at that point. So what does the process look like in time periods when going through a contested divorce? What should our viewers expect when going through that process?
Okay. So with a contested divorce, that is initiated by filing a complaint. And in Alabama, that is filed in the circuit court of the particular county. Then once that's filed, then we have to get the defendant served with that paperwork. Now, upon being served, that defendant has 30 days to answer. If they don't, then the plaintiff can move for a default judgment. Now, there's a lot that goes into that. I'll hold off on that for the time being, but assume that we don't get a default judgment in that matter, then that person who is served would file an answer and usually a counterclaim for divorce, expressing their particular issues in that divorce. And so at that point, then the matter can be set for what's called a pendente light hearing, where you have a temporary resolution with respect to child custody, child support, visitation, possession of the marital home, alimony, just to name a few. And then a lot of times that is referred to mediation for a potential settlement there. And if it doesn't settle in mediation, then ultimately you have to let the judge decide one way or the other what the resolution of those issues will be.
Mickey, I'm glad, I'm sorry to interrupt, I'm glad you mentioned mediation, because you are a mediator here in Alabama. And I'm pretty sure you run into some circumstances where they agree on some things, just not necessarily on everything. Can you just, for a quick moment, just give us some quick information regarding mediation to see if that could be a common ground during divorce?
Mediation is a form of alternative dispute resolution, meaning that it is a method that could lead to a settlement without having to go to court. The mediator is a neutral party, does not give legal advice to either person. That's because that's one reason, that's what they got the attorney for. and that mediator is floating back and forth between the two parties, hoping to help them to settle. Now, certainly if it doesn't settle, then the option to go to court is still there and let the judge decide. Now, if the parties are not able to agree on anything in mediation, then the whole set of issues will have to be decided. If some issues are agreed to and there are still some left unsettled, then there are circumstances under which you can do a partial settlement and let the judge decide those that are not resolved. Now, that is going to be determined by whether the parties are in agreement to do a partial settlement or not, whether their lawyers are going to advise them to do a partial settlement or not. But if you assume that the agreement is there to do the partial settlement, then they can go before the court and tell the court the issues that they have agreed to, and then try those that they have not agreed to and let the judge decide it.
Yeah, and one of the things you have to realize is if you can't settle on things and you have to go to court, there's a lot of things that have to be done from the time you enter that mediation and end it, if you can't settle, until the trial can take place. Some of that's discovery. So what happens there is the parties are essentially prying into each other's lives, asking for documentation or proof of bank accounts or any other records they may have. You know, you have to think about retirement accounts that you may have through your employer and how that's going to be affected in a divorce case. And there's a lot of things that will be affected. If there's children involved, you know, child support. There could be life insurance issues as far as you might ask your spouse if you have custody to and they pay child support to have a life insurance policy out there to protect your children until they're of age. In other words, if your spouse dies, there's really no more child support you're going to be able to get. So that life insurance policy can be set in place to help with that situation. And these are the kind of pitfalls we're talking about when you don't have an attorney. These are things that often will get overlooked. And those are the financial consequences I was speaking of earlier, that you could really put yourself in a bind and your family in a bind. So don't think you can, in just a matter of days, read on the internet and become an expert and know what to do in your case. And I believe one of these next sessions coming up is going to be about AI, and we won't get into that here. But the point is, it's best to have somebody that's experienced in your case, especially in your divorce case, because it affects so many areas of your life. It's an emotional time, especially if one spouse has just come in unexpectedly and said, hey, I'm done. It tears on your emotions, and you're not going to be able to make rational decisions, nor are you going to be able to make informed decisions about what the court's tendencies are when ruling on certain issues. That comes from the experience of being in the courtroom and being before the judges and knowing what their tendencies are. Because the judges in circuit court have a lot of discretion on their rulings. So what that means is they can listen to all the facts, and then they get to decide all the issues. And it might not satisfy either party. Both parties may go away upset, mad, blaming their attorney, or whatever. So it's best to think of all those things, and especially never go in the courtroom by yourself if the other side's represented by an attorney. You're just asking to get the wrong end of the stick there, so to speak. So don't do that. The biggest fool in the courtroom is the one that represents themselves, and they have the biggest fool for an attorney too. So don't be that person. Make sure you get good, solid advice. And when you're seeking out an attorney, ask them about their experience in this area. Don't just take their word for it. Look up, you know. Try to find out information on this attorney. Just don't go hire somebody on the street, especially because you can get a deal on your divorce. That deal may cost you money in the long term also, and heartache and other things. So be very, very careful. Understand that contested means just that. Nobody's agreeing on anything. and your whole life's going to be put before the court in that hearing, in that trial on your divorce. So it's going to be an emotional railroad coaster, and you don't need to go at it alone. You need an experienced law firm or attorney to handle those things.
I'm glad you mentioned about having to put all your information out there, and just it's a very like you said, it's not a pleasant experience to have to go through a divorce, let alone having to put your information out there for everyone to hear and for someone to judge. I think one of the things that people may not realize, because we see it in the movies, when people get divorced on the movies, it's just them in a courtroom with the judge, when in reality you can be in there with many other people having to explain their divorce cases as well. So you're all getting to know each other and all your business. So is there any other remedy, or is there any remedy or any other avenue someone can elect to in their divorce if they want a little bit more privacy and not have to go in there in front of the judge, in front of everyone presenting their divorce cases?
There are some circumstances, very, very few, that would allow for a divorce case to be sealed. But like I said, it's very, very rare and some very extenuating circumstances that would warrant that. Aside from that, the best advice I could give somebody is that if the case can be settled, it needs to be settled. Come to an agreement. And that goes back to the mediation that we were talking about earlier. If you go into the mediation, you're able to have assistance from an experienced lawyer who practices in the family law area, who also knows the judges in that particular area, and can say, I think this judge would rule this way or that way, and help try to facilitate a settlement. And one of the biggest advantages, especially in family law, of settling in mediation is that the parties are able to fashion and customize their own agreement that they can live with. They may not be completely happy with it, but once they understand that if they are diametrically opposed and they're able to give in a little bit and come to an agreement somewhere in the middle, and they've got that agreement they can at least live with, then they are able to agree on something that the judge might not otherwise have the power to order.
That's true. One of the other pitfalls I kind of skipped over was when these cases are filed, there's going to be, the other reason to have an attorney is there's going to be deadlines, filing deadlines, time to answer filings. There could be possible sanctions in a case if you don't do what's asked of you. If the other party files a motion for discovery and you don't answer those in time, the judge can actually sanction you financially for that. And then he's going to give you a quicker deadline, he or she, whoever the judge may be, a quicker guideline to answer. And then if you don't answer that, you know, they can possibly set your butt in the county jail for a couple of days to get your attention. So don't risk it. There's too many deadlines that can also affect your rights. And keep in mind, when you're in an uncontested matter, there's nothing speedy about it. It takes time. Court dockets are full. Things just don't move at a pace that most clients are going to be happy with, but that's something that's out of our control in a lot of cases because of the court system. And again, I'm not blaming the court system. It's because there's, you know, the courts handle all kinds of civil and criminal matters, and, you know, you just have to think of the area we're in is growing rapidly, so the court systems are getting more and more backed up. That's why we've gotten a new district court judge seat coming up soon, and so to try and handle all this. So you need to be patient, and you need an attorney, like I said, experienced, to help you through this process and be able to answer these questions for you that are going to come up. Because again, it's probably one of the most stressful times of your life you're going to go through will be getting a divorce from somebody you thought you were going to spend the rest of your life with, and especially if kids are involved.
One of the things I really pride our firm on, and I see the value in our firm when talking with people about divorce, is that we have such a variety of attorneys at our law firm. That's why we cover most areas. But within that, we roundtable cases, we talk to each other about them. And so one of the things I love about our firm is not only are you getting experienced family law attorneys, but nowadays many people own businesses or are trying to start their businesses, and that can come into play when you're going through a divorce. So we also have attorneys that have experience, a large amount of experience in business law. So when you have a business law attorney and a family law attorney collaborating to try to get you the best outcome, I think that puts us a little bit ahead of the curve on that. So I really take pride in our firm being able to help on a multi-level surface for our clients. One of the things falls into a question that a viewer submitted that I think kind of rolls into this is spouses hiding assets. That's another reason why you need legal counsel, is because your attorney is going to be able to spot that and analyze that. So Bennett, would you mind touching base on just how to approach that scenario and what happens if we do find out a spouse is hiding assets?
Yeah, not at all. I mean, it does happen. Mickey, have you ever had this happen in your many years of practice?
Oh, yeah, a time or two.
Oh, yeah, a time or two. It's not uncommon. Look, there are telltale signs sometimes. And what I mean by that your spouse is getting ready to leave you. All of a sudden, they've opened a separate bank account, or they've become a little secretive about their finances, or those can be warning signs that they're stashing away some assets to try to avoid you being able to attack those in the divorce. And there are certain guidelines and things for who can get what, but the judges have a lot of discretion when splitting assets, and that's why people will attempt to do that. Again, not to harp on hiring a good attorney for this, but hire a good attorney, because there's plenty of cases out there where we found that people are doing whatever they can to hide their assets before they file, because once they file, most courts in this area in North Alabama have general guidelines once the divorce is filed on what you can and cannot do with your assets at that point till there's a final hearing in the matter. Those are usually called standing orders. So, that means they probably went and talked to another attorney who's well versed in divorces, and they've kind of said, well, you could do this and do that, but if the court finds out, it's not going to look good. But, they may not have listened to their attorney and tried to do it anyway.
That never happens.
No, it never happens.
Of course not.
So the point is you look for those signs. That's usually the biggest part of a contention in a divorce is the assets, other than the children. I would say the children are first, that's second. But don't be offended if I say this, but not all the time. I've seen it where all the spouses were worried about were their dang assets, excuse my expression there, instead of what's going to be best for the kids involved, which is really frustrating and irritating to me. But there are people like that. So just keep that in mind. People will attempt to do this. There are ways to cut that off through filing certain motions with the court if it's outside of that standing order, to try to make them freeze their assets so that they don't get away with a big chunk of money hidden somewhere from you. Any additions, Mickey?
I think you pretty well hit the nail on the head there. There's pretty good recitation there. One thing that I would suggest, though, is that Bennett has mentioned a couple of times about the discretion that the judges have in Alabama. And that really boils down to if you wanted to take your divorce or divorce-related case on appeal to the Court of Civil Appeals, that discretion that Bennett was speaking of is what comes into play there, because whatever that judge rules is presumed to be correct. And if you take that up on appeal, the burden is on you to prove that the judge has abused discretion. And that is not an easy thing to accomplish. It's not impossible, but it is an issue that I've had to advise clients about many, many times over my career, of how hard or easy it might be to get that opinion, that decree overturned.
Well, we got time for one last question. Mickey, I think you've touched base on this, but just as a reminder, if a divorce starts off as contested and they end up going to a mediator or coming to an agreement, what needs to happen after that? Basically,
in a nutshell, it's almost like it's transformed from a contested to an uncontested, which would amount then to filing the necessary paperwork, which would be an amended complaint, the answer and waiver, the affidavit of the plaintiff, the settlement agreement. If there are children involved, and we're talking about child support, there are certain forms that calculate the child support and it gets submitted. It would just be a matter of fixing up that paperwork. Now, if you go through mediation, many times the mediator will fix that up for you and allow the parties to sign along with their attorneys, and then the mediator will see to it that it gets filed. If you settle without a mediator, then oftentimes that's circulated between the attorneys and gets filed by one or the other of the attorneys.
Now, correct me if I'm wrong, but when you go in front of the judge, do they typically encourage you to try to come to a resolution before a trial?
Some judges will say something along those lines. Have you had a chance to talk? Would you mind talking? Do you want to take a stab at it? Other times, the judge will just flat out order the case to mediation and say, I'm not going to hear the case.
You have no choice but to do it.
Right. And look, don't get me, I don't say that to speak pejoratively of any judge. We have a great set of judges in Madison County and a lot of the surrounding counties that I've been in front of over my career. And so when I say that, the judge can order the mediation, and that can be a good thing. And I've had to explain that to clients that, the judge is going to order this to mediation, then you got a chance to settle this thing. And if it can't settle, you still have the chance, like I mentioned earlier, to go to court and let the judge decide it. But mediation is a very good opportunity for the parties to come together and try to settle the matter.
Thank you. That's very, very great information for our viewers at home. If you have any more questions about divorce, please send them in to Legal Help at JMMT Law Firm. We'll be happy to answer them on air. And if you're going through a divorce, please reach out to us. We'll be happy to help you there as well. Thank you, guys, and I hope you have a great week, and we'll see you next Sunday.
Thanks, guys.
Thank you.
Bye.